case briefs, and so much more. LSData's got what you're looking for.
In 1987, Catrett v. Johns-Manville Sales Corp. was heard by the United States Court of Appeals for the District of Columbia Circuit. The case centered around Mrs. Catrett, who filed a lawsuit against 15 corporations, including Celotex Corporation, after her husband died from asbestosis, allegedly caused by exposure to asbestos-containing products. The district court granted Celotex's motion for summary judgment, stating there was no evidence of Mr. Catrett's exposure to their products. However, the Court of Appeals reversed this decision after finding sufficient evidence for a genuine issue of material fact. The Supreme Court later overturned the Court of Appeals decision, ruling that parties seeking summary judgment only need to identify the parts of the evidence that support their motion. Mrs. Catrett's case was then returned to the Court of Appeals to determine if she provided enough evidence to avoid summary judgment. The court held that there was indeed sufficient evidence for a genuine issue regarding Mr. Catrett's exposure to Celotex products. This evidence included a letter from Mr. Hoff detailing Mr. Catrett's work with firebar fireproofing, which was allegedly manufactured by Celotex. The Hoff letter was deemed admissible despite Celotex's objections. The case was remanded for further proceedings, including witness testimony. Celotex was found responsible for Kerry Canadian's liabilities, but could argue against liability for any damage caused by firebar. As a result, the evidence presented in the case was deemed sufficient to warrant submission to a jury.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.